So what you do is the attorney comes up and says, you know what, I want to mark this exhibit. Okay, so you take the exhibit, put it on your, get an exhibit thing, put it on there, mark it. Before you give it back to him, on your information sheet, you put it on there. Add items, 1, M, mark. On your machine, mark, add items, 1. Then hand it back to him. Once you hand it back to him, they're going to start talking. You're not going to have any time to do all of this stuff. You do this stuff before you hand it back to him. Okay? Does that make sense?
So you don't put a description, but put it on your information sheet.
And you can. You can put, you know, at item 1, picture. Well, you're already going to kind of know what it is because it's in the transcript. So if you go to mark it, you're going to kind of know what it is. But, I mean, it's a good idea to mark it on that information sheet exactly what it is. You know what? It was a picture. Okay? Or an order. Or a lease. Okay? Just something simple. Keep it simple. Marking different objects. You may have to get creative in marking some exhibits, and certain precautions may need to be taken. For the most part, exhibits can be marked with labels or tags, but some unusual objects may require additional consideration. These objects are discussed in this section. Okay? Marking papers that are paper clipped together. When a group of papers is presented as one exhibit, make sure they are all stapled together and not paper clipped. Paper clips become loose and papers can be lost. A staple will guarantee that the papers remain as one unit. If in doubt about stapling them together, ask the court or the attorney whether it may be stapled together. Okay? So they may want them apart. They may have a paper clip for a reason. You know what? I want the witness to be able to go through them one by one and not have to keep flipping the pages, just to where they can take it off and they can, you know, go through each individual page. Because the exhibit is considered as one exhibit, your marking will reflect the different pages within the exhibit. For example, if plaintiff offers exhibit number 26 and it contains 17 pages stapled together, your exhibit number will be P26-1 through P26-17. I mean, I guess. I've never been asked to do that. But I mean, if that's the way that they want it, then yeah. So if they want them marked as individual exhibits as one, then yeah. I guess so. You in the back.
So it says to mark each page P26-1, P26-17. Now on the second page, would you write P26-2?
Yeah.
P26. So you do 2, 3, 4. That part changes.
That's what they're saying here.
You have to do one every.
But I mean, that doesn't make sense to me, because if they're going to mark it as one exhibit and it's already stapled, and they're just going to say, you know what, go to page 4 and, you know, whatever. But they may say that. They may say, you know what, we want it marked as one exhibit, but we want it dash whatever. Okay? Which doesn't make sense to me. Just mark them as different exhibits. P26, P27, P28, P29, you know, whatever. Most of the time they're going to want to do that rather than do -1, but I guess they're just saying it could happen. So if so, that's how you would do it. Marking envelopes or bags containing various items of evidence. Items that are so small that cannot be physically marked are often placed in envelopes or small clear plastic baggies. Okay? For example, you know, small bullets, fragments, nails, screws. You know, like I said, you know, they brought those panties in one time. You know, they just had it in a Ziploc bag. You know, so I mean, and I just had to mark the bag. But I mean, you're going to get different items like that. You're going to get all kinds of stuff. You know, so just be prepared. I don't know, here they're kind of mentioning that same thing again. If the baggie or envelope contains more than one item, note the quantity in the description, and in some cases by numbering and lettering. For an example, an envelope containing 3 broken bolts from a suspected wheel involved in an accident may be marked as P-1-A, P-1-B, P-1-C. I don't know, maybe. Usually they're going to mark them as individual exhibits. P-1, P-2, P-3. You know? Marking substitute for original exhibits. Attorneys often request a substitution of a copy of a document in place of the original, especially in the case of an expert witness's license, diploma, or certificate. That's true. You know what? They're not going to give you the original to mark it as an exhibit. You know, so they're just going to take a picture of it and bring it. Yeah, I mean, I graduated from Michigan State University. Here it is. I took a picture of it. Okay? That's what they're saying right there. Make dry erase board and blackboard drawings as exhibit. Very often a witness will be requested to draw a picture of a scene, location, accident, or the like. The drawings may be made on the blackboard using chalk or in a large dry erase board using an erasable felt tip marker. After the drawing is made by the witness, the attorney may offer the drawing as an exhibit, either to be marked or for identification or to receive it into evidence. The drawing is marked using a label, chalk or felt tip marker in one corner. Then the attorney who introduced the exhibit must verbally put into the record that a photograph will be substituted for the actual drawing. In the criminal case, the sheriff's department or bailiff of the court arranges how to have a photograph of it taken. So they're not going to admit the whole eraser board, okay? So if it goes up on appeal, the Fourth Court of Appeals, you know, you're not carrying this, you know, eraser board up there, you know, for them to see it. But, you know, a picture is going to have to be made of it, okay? So usually you're going to be responsible for that. It's saying that the bailiff is, but usually you're probably going to be responsible for that, okay? So sometimes, I don't know if you can do it by phone. I've never had to do it. I really have never had to do it, so I have no idea. You know, whether you would have to get an actual camera or whether you can do it by your phone and send it to your email and then print it there or what, so. Marking bulky items as exhibits. Large bulky items are often introduced into evidence in a trial, and such photographs are not often used to depict the actual evidence being introduced. In the case of an automobile, locomotive, a burned building, or the like, photographs are used to tell the story, and photographs are marked for identification and received into evidence. So, I mean, you know, most of the time with big stuff like that, I mean, it's going to be, you know, pictures. Exhibit parentheticals. The parenthetical that you use in your shorthand notes can be very quick notations that can be filled in at the same time of the edit. It can be a computer-generated include command that will automatically insert a predefined parenthetical. And that's what it is. You know, when I mark an exhibit, that's what I do. I do mark on my machine. And it automatically brings in a parenthetical that says, whereupon, and I think I told you guys, it's, you know, it comes like this, and it says, whereupon, and it has the box, exhibit number, and it has a blank box, was admitted. Okay? And what these things are called form fields. So these are things that can be filled in every time you do it. So you don't have to write this thing out every time, okay? You don't have to write that thing out. Every time you do mark, you have an auto include that includes it in your transcript, okay? And then what you do is go in and then just fill these fields in. So it doesn't matter if it was petitioner's exhibit number blank or ad litem's exhibit number whatever. You don't have to have a different mark, ad litem, mark, plaintiff, mark, petition. You don't have to do all that. All you do is mark. This thing will fill it in for you. Okay, so when you need to go fill it in, you push the button, which is what? You remember? E. E on Eclipse will fill in a blank. You push E, come right here, add items, number 1. And then that's it. All you have to do is mark. And if you take the Eclipse class, you're going to find that out in the advanced Eclipse class. So you'll find that out then. But that's all it is an auto-include or a parenthetical. And that's what they're talking about there. Who marks exhibit and what happens to them? During depositions, exhibits are marked by the court reporter when requested by the attorneys to do so. The attorney providing the exhibit may request the court reporter to retain the exhibits and file them as part of the original deposition. If the exhibits are made part of the deposition, the original exhibits are usually placed in the back of the original of the deposition, and copies are placed in the back of the attorney's copies. So if they give you, pictures of whatever, they say, you know what, we want to keep it with the exhibit, with the original deposition. Okay. But you have 4 other attorneys in that case. I want a copy, I want a copy, I want a copy, I want a copy. Okay. So they get a copy of the exhibits too. So now you have to photocopy what the exhibits were and make sure that they get a copy of the same thing that you're putting on that original. Make sense?
Do you need to know anywhere on that you gave them all copies on their deposition? Would it say copy?
What do you mean?
Because you said the originals go with the original transcript, and then I have to make them copies. Do I need to know anywhere that I made them a copy of that, or it's just like,
Or you just make them copies and send them off to them? Here you go.
No, it'll be with the transcript itself. So you have the transcript, and the transcript is like this or whatever. At the back of the transcript, you're going to put them back here
right.
on the final thing. Staple them or whatever, or they'll, whoever you go to work for has a certain way of doing it, and they're going to put those on there.
Right, but those are the originals. So when I'm making copies of that original, do I need to state anywhere on those other transcripts if they're copies, not the original?
Oh, they'll know.
Oh,
Yeah, because if it's on the copy, then it's going to be the copy. And they're going to see, like especially pictures. You're going to have the original pictures there. The other ones are going to be sheets of paper like this that have the picture of the whatever on it.
What about documents?
Same thing.
But you wouldn't know.
So on the front of the deposition, you're going to have original. So it's going to have original. So they're going to know that the original exhibits are on the original. And on the other ones, you have a stamp that has copy. Is that what you were asking?
Yeah.
Okay. Yeah. That's how you'll know the original from the copy. Okay?
you charge less for a copy?
Yeah. Yeah. So like for ours, the original is $3.50 a page, and the copy is $1.16. Yeah.
Who gets the original?
The person taking the deposition will get the original, or the person who requested the transcript.
Oh,
So like, it doesn't matter. The state is the one who put on the case against these people or whatever, but the mom's attorney is the one who said, you know what? I want a copy of that transcript that we did today. Well, she's the one that came and requested it. So I call all the other attorneys, hey, look, mom's attorney requested a copy of this deposition or whatever. Do you want a copy? Yeah, I do. Yeah, I do. Yeah, I do. Dad's attorney, ad litem, state, all 3 of them want a copy. Okay. So mom gets the original because she's the one that requested it, but she's also the one that gets charged $3.50 a page, which the county pays for it or whatever. But if it's somebody in a civil case and they're all retained attorneys, the price is different. Now the price is anywhere from $5 to $6 a page. And what you do is you charge 1/3 of what you charge for the original. Does that make sense? So if it's $6 a page, $2, because it's a third, is what you can charge for that copy, and that's it. You can only charge a third of what you charge for the original.
So whoever asks first, basically, gets
Gets
the original.
the original.
So someone could be hanging around like, I know she's gonna want that, but I'm gonna let her request it, so that way I can take.
And most of the time they do.
So they-
Most of the time they'll call and say, hey, somebody request that Davila transcript? Not yet. Well, are you gonna call me if they do? Don't I always? Oh, okay.
You do have to let them know, right?
Yeah, you're obligated to let them know. You have to let the other side know that the other side ordered a copy of the transcript. Now, whether they want it or not, that's up to them. But you're obligated to let them know. You're obligated by statute. You know, so yeah, you're obligated to let them know that it's been ordered. Okay? Any questions about that? A final note about exhibits. As the guardian of the record, the court reporter is ultimately responsible for keeping track of all the exhibits, how they are marked, and who has them. Therefore, the court reporter keeps a good record of the exhibits on his or her information sheet, marks the exhibits using an appropriate sequential numbering system, places proper parentheticals within the transcribed record, and knows exactly where any given exhibit is at any given moment. Yes. You know, and in some of the thing of, you know, what happens to them or whatever, you know, some official reporters always go over with the judge and the attorneys the exhibits that are and aren't admitted into evidence before it goes back into the jury room with the jury. Very smart to do that. Okay, guys, Judge, I want to go over with you the exhibits that you have. And usually the judge they'll take pretty good notes about what exhibits are marked, which ones aren't. The attorneys are pretty good about which ones are marked, which ones aren't. You know, hey, look, you know, these are the ones that I have. You know, what do y'all have? Yeah, those are, yeah, that's good. And the judge will go over with you, yeah, I had states exhibits 1, 2, 3, 4, 7, 8, 9, 10, 12, 15. The other ones were not admitted. On the items, I had 1, 2, 6, 7, and 9. That's it. Okay, that's what I had. Okay, gather up the exhibits, take them in. Okay? Digital document and exhibit management, along with electronic exhibits that are produced in digital format, court reporters may offer digital exhibits that are automatically become part of the record when scanned into a device. Documents are scanned into a scanner, which creates a digitized image of the document. Modern courts have exhibit managing equipment as part of their up-to-date equipment, and many court reporting firms offer digitized documents as part of their litigation support. Even when sending it up to the fourth court, it's the same way. They don't want the exhibits. They want just a copy of it. That's it. So now you have to go on the copier and, you know. So when you have an exhibit, I'll tell you right now, always try to put it on the front. Because if not, then you have to shoot a copy of the exhibit, turn it over, shoot a copy of the exhibit sticker. Yeah. You'll learn. You'll learn. That's not the way to do it. And, you know, I learned the hard way too. So it is what it is. Any questions about exhibits? Slick? Hmm? I know. Y'all doing the little exercises afterwards?
Yes. Looking at the movie.
Huh?
Looking at the movie.
Guys, when I ask you to read the chapters, I want you to read the chapters, do the exercises afterwards, okay? Every week. So when I come through, we don't have a whole lot of time because we just have so much to cover you know, we need to go through these things. So if you have any questions about stuff, well, why are they saying, you know, all plaintiff's exhibits are marked with numbers and all blah, 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 and this, that, and the other? Why is that? Okay? So I want y'all to go through these exercises and do them also. Okay? How to read back and testify. Reading back. Sometimes whole court reporting sessions will go by without anyone asking for a single readback. Then again, during depositions or hearing, requests to review testimony seems to be endless as attorneys object or witnesses fail to speak loudly. You may be asked to read an entire day's testimony or a long statement by counsel to the jury or to the court and counsel chambers. Okay? Practicing reading back. I mean, you guys do that all the time. Okay? You know, and I told you, you know, one thing, you know, that you should do, always sit up straight. You know, you're not, you know, looking at your notes and blah, blah, blah. Always sit up straight, okay? Always sit up straight. Always read ahead a little bit to make sure that you know what you're reading, and then keep a nice, smooth voice. You don't have to read fast. It doesn't have to be, just keep calm. Just keep calm and just read, you know, like you would. I want you to read that back, okay? Question. Discuss the various reasons why a readback situation might occur. Answer. Explain how to read back, including finding and marking readback spots in steno notes. You see how that wasn't fast? It wasn't. Question. Discuss the various reasons why a readback situation might occur. Answer how to read back. No one's going to understand that. One, you're jumbling over yourself. And if you come to a spot where you have a little bit of a, oh, what did I put there? Oh, I dragged the G right there. No big deal. I know what that was because of reading the context. Now you're, so now you've gone, explain how to read back, including finding and marking read back, and you know, it sounds ridiculous, guys. Keep it nice, keep it uniform, just the same, okay? It doesn't have to be fast. You know, speak up and not explain how to read back, including finding and marking reading spots. What? No one can hear that. Speak up. And it doesn't have to be, you know, you don't have to shout. But I mean, just like you will hold a regular conversation, you know, and even if I'm speaking to her in the back, to where she knows she can hear me. And I know that she can hear me. Not, what? I can't hear that. And the attorney's going to have to ask you, huh?
So don't talk trash about her.
Get one of these, MMA. You know, keep it uniform, okay? Develop a readback voice. That's just what I was talking about, okay? Succinctly, a readback voice is a voice that can be heard by everyone present in the room. That's really all it is. Pretty simple, okay? Take time to read. Perhaps one of the most important things to remember when reading back is to take your time. Guys, I don't care, and this is where you should practice, is in school. You know, when they ask you to read back, don't get all flustered and whatever, you know, sit up, look at it, read ahead a little bit, then read back. And if they ask you, read back, you tell them, hang on just a second, I'm making sure everything is right. You know, especially here in school, you tell them if there's a problem, they can call me, and I'll tell them why to do that. You don't, question, perhaps one of the most important things to remember in reading back, and then you, is to take your time, and then you have to stop, start, stop, start, stop. Just keep it uniform, okay? And that's what they're saying right there. Remember, you are in control of the situation. Never begin reading back until you are 100% sure of yourself. All right? Same thing here. Why readback situations occur? Readbacks usually occur for specific reasons. The original question may have to become so garbled that it needs to be rephrased, or to rephrase it, the attorney who asked the question needs to know what he or she even said. Most of the time they're going so fast they don't even know what they asked. So they forget what they're asked, or the witness will kind of turn it around and say, I don't even understand what you were asking. Ask it again, or ask it a different way. I don't even remember what I asked. They'll do that all the time. Okay, so just be prepared. How to read back. In reading back, read only what is in your notes. If you come to a difficult section in your notes, read it back as best you can. Lawyers and witnesses often speak in broken sentences. Read back broken and dashed sentences just as they were spoken. Okay? So you see how it can get messed up when you're reading too fast? If the attorney goes, the time that you went to the store, well, the time that you went to the store, the time that you went with your brother to the store, let me strike that. And he's already started 3 different times. So now you're going to read it back. The time they went to the store, the time that he went to the store, the time that he went to the brother with the store, and you're reading so fast, it all sounds like you messed up. And you dropped. That's why you read it slow and uniformly. Just like they said it, just slower. And just read it uniform. You don't have to get fast, whatever. You just keep it nice and calm and in a nice, even flow. Okay?
Do we pause for them when they're hesitant like that? Do we have to sound kind of hesitant when reading back so they understand?
Yeah. So they understand and they're going to, well, what? Well, there were dashes there. You start it again. So if they ask, then you tell them. Well, what happened there? Well, there were dashes there.
So we don't say dash. We just emphasize
Yeah,
in our
just emphasize in your voice. The time that I went to the store, the time that I went to the store, the time I went with my brother to the store, strike that. Let me start again. You see how you could tell, just like that. How to read back. In reading back, read only what is in your notes. Read back broken and dashed sentences just as they were spoken. And that's what I had just read. And it's the same way. Okay. If you stumble on a word or a phrase, remember that it is not the end of the world. And it's not, guys. I mean, things happen. It's no big deal. Okay? They're going to understand. And if they don't, then it is what it is. I mean, we're human. Okay? You read it back as best you can. And, say it was something real close and you said, brain dead right now. But I mean, and you just kind of fumbled over it a little bit and say it was, did you go to the store with Mrs. Garcia? Oh, I'm sorry, with Mrs. Garza. Garza. Did you go to the store with Mrs. Garza? And, your brief for Garcia and Garza is so close that maybe you stroked it wrong. But you remembered, you know what? That was Garza. They've been talking about Mrs. Garza the whole time. There is no Miss Garcia here. But in my notes, it has Garcia. But they were talking about Garza the whole time. There is no Miss Garcia. No big deal. I'm sorry. Garza. And they may correct you. What? Miss Garcia? Oh, I'm sorry, guys. Mrs. Garza. I had it jumbled up in my notes. I was checking to see if you guys were listening. Stuff like that. No, I mean, it's not the end of the world, okay? That's it. It happens. It happens. So don't freak out. Finding and marking readback spots. Court reporters need to devise a good method, and that just goes back. I don't do it. You know, if they ask me, you know what, go back and read the last question, then I just pull it up to the last question. It's no big deal. You know, if you know that you're going to ask me read back, ask to have it read back, then, you know, if you want to mark it in your notes, I guess you can. You know, but I've never done it. Reading back to the jury. Juries often forget what a witness said during testimony, or they can't remember what a witness said on a certain thing. Sometimes, too, they think that they heard a certain thing said, but their memories are faulty. In such cases, the reporter is called on to read portions of the transcript back to the jury. In some cases, one or two questions and answers may be read. In other cases, the entire testimony may be read. It happens. It happens. So, I mean, just be prepared. But like I said, when I got picked on jury duty, you know, about a month ago, I mean, the judge was like, pay very close attention to the evidence that's going to be given. If you want to take notes, you can take notes or whatever. And she even said, in her opening little spiel to us, she's like, the court reporter is not going to read the whole transcript back to you guys. And she's not going to read the whole testimony of one witness because you guys didn't remember. Take notes. Try to remember. If there's a discrepancy on a certain question, she'll read back a certain question and an answer, but she's not reading the whole thing back to you. So, all depends on the judge. Depending on what material the jury wants read back, the readback may take place in open court with all parties present and the reporter seated in the witness stand, reading back the requested portion. Sometimes the reporter will read right from his or her normal place in the courtroom. Occasionally the reporter will go to the jury room and just read it back. And a lot of times they will. They'll say, you know what, you know, just, you know, take your computer, you know, back in the day we used to have to take our notes. Take your notes and read back, and the judge would be in there and the attorneys would be in there in the jury room, and it's just like, okay, read it back. Okay, did you go to the store with your brother? Question, did you go to the store with your brother? Answer, yes I did. Okay, that's it. Testifying in open court. Sometimes court reporters are required to take the witness stand and testify as to the contents of their transcripts and the accuracy of their notes. Although this type of questioning may seem unusual and may appear to be questioning the integrity of the court reporter's work, this is not always the case. I got called upon to do that. Yeah, once. And the guy was questioning, you know, whether what I had in there was correct. And it's like, absolutely. Absolutely it was correct. And he's like, okay, well, you know, we thought that he said, well, he didn't. He didn't.
Do you have to show them the recording or let them hear the recording?
No, the recording is my work product. So what I did was I made sure with the recording that it was correct. And it's like, yeah, that's exactly what he said. Okay. I had a witness one time tell me that too. And what's, like in a deposition you have, on the original, they have what's called an errata sheet. The errata sheet is where they make corrections. You know, and this guy had a page and a half of corrections. That usually doesn't happen. And it was on mine. I had just gotten out of school or whatever, and it's like, what? And you know, the firm owner called me and she goes, Dave, there's a page and a half of corrections on this thing, and they're saying that they didn't say this. It's like, there's no way. I mean, if I messed up one or two times, maybe. But I mean, even then, you know, I go through so diligently, you know, with the recording, then I go back and proof it again, Then I go back and put the corrections in. So you've already seen it 3 or 4 times. It's like, there's no way. Well, now they're questioning. Now the attorney was questioning. No, this is all wrong. My client is saying this was all wrong. She's like, bring it up here. Brought it up there, my recording, and just she and I listened to it, and it's like, I listened to it first before I even took it up there. It's like, I want to make sure that it's correct. Everything was there. So I had a copy of the errata sheet, and I went through each thing. He changed every answer he had. He just changed it. And she's like, no, no, and calls him back and says, absolutely not. We listened to it. Well, I want to listen to it. No, that's my work product.
You don't have to let.
Well, he argued so much, so we brought him up there. You know what? Come up here. But my reporter, he's going to charge you for his time because your witness is lying. We sat up there for an hour. One time with him and I said, well, I didn't remember saying that. Well, I didn't remember saying that. Seriously? 40 something times you didn't remember saying something? Okay, whatever. It was there. I was correct.
But why wouldn't you want to show them I mean, it is a reputation, your reputation that you have amongst attorneys. You know what I mean?
Yeah.
So why wouldn't you want to show him?
I did.
I mean.
I did. You know, and if I had made the mistake, then I would have told him, you know what? I made the mistake. I'm sorry. He said that he did not live on, or he did not do that crime in 1989, and I put that he did do the crime. Well, that's what I heard. And then I went through and heard the tape and on editing, and I heard the same thing. And then when I went through and proofread it, I saw it again. So I messed up 3 times. Not likely, but maybe. It can happen. Not likely, but whatever. But no, he had messed up. So, yeah.
Is the attorney allowed to have a recorder?
I'm sorry?
Is
No.
the attorney allowed to record the proceedings?
No. And even when you're in court, you're not allowed to record those proceedings. And we just had that happen about a month ago, where a mom was sitting there recording the proceedings on her phone.
How did y'all find out?
Because I saw her phone right there. I saw her phone, you know, was out there. And really, you're supposed to have your phones off. You know, like if it's in their purse, I mean, I can't see it. But, you know, she had it up there, you know, just right there. And I motioned to the bailiff and I said, you know, in between one of the proceedings, and I texted him, I said, I think this lady's tape recording. So he went and told the judge. So the judge said, you know what, we're going to take a break for a second. He came over there, he said, do you think so? I said, Judge, I'm telling you, I think, yeah. We came back out and he said, you know, we got started, and he said, ma'am, I'm going to tell you something, you're under oath. So if you don't answer correctly, it's perjury. Are you recording these proceedings? Yes, I am. He said, that's against the law. You're not supposed to be doing it. Had the bailiff pick it up, erased everything on her phone with the proceedings. She was taking pictures. I don't know. So it gets dumber, trust me. So she had a guy that was there, a friend of hers, supposedly. He's in the back of the courtroom. So he's got this bag, and I'm putting it up here. But he's got this bag, and you know what? If the phone's in the bag, I don't see it. He has the phone like this. I'm not kidding you. Just like that. Where I can see him in the back of the courtroom. So I text the bailiff, and I said, that guy's recording the proceedings, I guarantee it. So he goes back there, takes the guy out. The guy goes outside and they come back in, and you know, the bailiff comes up to the front, he talks to the judge, and the judge says, stop the proceedings. We're still on the record, stop the proceedings. He said, sir, come up here. He said, were you recording these proceedings? Yes, I was. He said, did you not just hear me tell the mom that it's against the law? Well, why were you doing it? Well, I thought I was just trying to help her out, and I thought it was helping her, and take it, erase everything. The bailiff took him outside and made him cry. Grown man. I don't know what he told him. Scared him, made him cry. I don't know if he told him he was going to jail or what, but yeah. So no, you're not supposed to record the proceedings. No. So yeah, that was kind of a funny story. And it just happened like a month ago. Yeah. What to do when testifying. If you're called to testify regarding a matter that you have reported, take the original notes to the court with you. Arrive early so that you have an opportunity to discuss your testimony with the attorney who requested your presence. Sometimes attorneys who see notes that contain other markings may question why the notes are marked up. You merely need to explain to them that the marks are part of the editing process and that notes are cleaned up for your transcription, editing, and does not always change the accuracy of the notes nor their reliability. The attorney may ask you to read portions of your notes while he or she is holding the transcript that you produced. If this is the case, read calmly and coolly. Usually the attorney reserving the questioning and the portion of the controversy, but some attorneys may ask you to read other portions. So, don't freak out, whatever. I mean, just make sure that what you have is there and that you read back. Type of questions to expect. After you are placed under oath, you will be asked to state your name, address, and business or profession. Next, you will be questioned about your education, qualifications, and experience as a court reporter. Be totally honest, but not so modest that you do not prove that you are capable of doing your job and doing it well. Inform the attorneys that the court about the months of training that you have to undergo to get to where you are, any tests that you have passed, and rewards, and so on. I didn't really have to do that. They just kind of asked me my name, who you're the court reporter for, Judge so-and-so. Is it true that, my client said this? Yeah. You testify under oath? Absolutely. Okay. Well, it's the same thing when you certify to that transcript. You're swearing under oath that that's what they said. So it's the same thing, but I don't know. So all of this stuff, if you read through it, this is kind of general. They're going to ask you, what you do, how you do what you do, and blah, blah, blah. So, I mean, a lot of that is self-explanatory if you read it. Reporting and testifying. At some point in your career, you may be called to testify about your own notes, and because you are the only court reporter in the area, you have to take your own testimony. Although this situation does not happen very often, as a rule, you would write the question posed by the person asking the question and then write your answer without saying anything verbally. After writing your answer, you would read your answer from what you wrote. I suppose. If you're that court reporter in a one-horse town, maybe so. I've never heard of this before, so. But I mean, if you're called upon to do it, that's how you do it. Okay? General guidelines, just be totally honest about your answers. If you do not remember something, just say so. That you don't remember. If other witnesses were to testify differently, you would have a credibility problem testifying forthrightly and confidently. Always keep in mind that judges, attorneys, juries, and public want to believe that you, as a court reporter, do a fine job day after day. You must do your part to help them believe in you by being a good witness when called upon to testify. And that's if you're ever called upon to testify or whatever. So. Okay, guys, I guess we're done for the day. I know we only covered a couple. I mean, those were long chapters too. So, what did I ask you how to read? 12 through 15? 12 through 15? Okay, you've already read 15. So read it again. 16 is quick. '17 is going to be pretty quick too. and 18. So 15 through 18 for next week. Y'all have any questions about what we've covered so far? Exhibits, any of that stuff? No? All right, we'll see y'all next week.